In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda.
I want to state that, as without fear of contradiction, the Supreme Court did not say that civilians cannot be tried in the court-martial.
Today, the UPDF Act has been tabled in Parliament, which is aiming at fighting or settling political scores. We all know the court-martial was disqualified by the Supreme Court, and now General Museveni wants the court-martial to come back so that it can bite his political opponents. Okay? And we all know the process in which an amendment passes through is public participation. Today, an invite was sent to the Secretary General of NUP so that he can have an input in the UPDF Act. In a tweet which was outed by David Louis RUBONGOYA, he came out to say, and I quote, "Very unfortunate to see the Parliament of Uganda behave in this manner. This morning we received this invitation to appear and give our views on the UPDF amendment bill. The invitation was for today at 9 a.m. Yesterday, an advert in the newspaper asking for the public to give their views by close business today. This link was provided through which people would access the law wasn't working. In fact, I tried to check last evening and the website was off. You can see how eager they are to pass this unconstitutional law, even if it means violating every law in the book." Well, we wrote back asking for ample time to prepare our response to this very problematic law that seeks to illegally take civilians back to the military courts. NUP members have been gravely persecuted through the military courts for whatever worth it may have. We want to be on record about our strong objection. Free Uganda. That is a tweet which was written by the Secretary General of NUP, saying that they had invited him to put his input in the amendment of the UPDF Act. We all know that the UPDF is used to play politics. In fact, the recipe of disaster is the army engaging in politics. It is what is happening. So in this episode, I've come to talk about the UPDF Act which is being brought in the floor of Parliament, what it means for our politics, and most importantly, the study materials we can learn from the politics of our nation. But before I do this, I want to show that if you're new to this channel, please subscribe. And if you're watching this video from a different platform, please head on to YouTube, type in Sula Mawagari. There's a lot of content of this nature. If geopolitics and economics is what you want, this will be definitely the right channel for you to subscribe to.
With the advice of the Attorney General, who did a lot of research, we compromise on that one. That now, in the appointment, we shall do it in consultation with the Judicial Service Commission. If I was saying this somewhere else, I would have asked for the applause.
I want to state that, as without fear of contradiction, the Supreme Court did not say that civilians cannot be tried in the court-martial. Like Honorable Katuntu said, different judges went through it in different ways and arrived at this different conclusion, to the conclusion that the court-martial, as it were constituted, and the way it had been set up in the law was not constitutionally set up to try civilians.
First of all, the court-martial has always been used as a tool to coerce political opponents. Okay? Since its inception, it has been biting opposition leaders. In fact, bigger cases are with political opponents, from Kizza Besigye, from Tumukunde, from Kiryowa, from Bobi Wine. Every big contender was testing the court-martial. Not until the Supreme Court came out to annul it. In fact, here is the ruling which was made by the Supreme Court. Here's the tape.
Must immediately cease. Recording.
This is not 12-9. I said all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. 3. This judgment, you just nod, don't stop this clapping. I don't. The sentence is being challenged in a court of law. All pending trials or partly high criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to civil law, must be transferred to the civil courts with competent jurisdiction. 5. It is nonetheless important. Court-martial are not unconstitutional merely by their very nature of being military courts. The people of Uganda pronounced themselves in the course of the making of the 1995 Constitution, expressing their fervent desire to make a break from the ugly past that characterized life in our country, especially the grave abuse of human rights by the military. The Ugandan military has since been transformed into a professional force, and it has made remarkable contribution to ensuring regional peace.
In their current form, courts-martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts-martial save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts-martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts-martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts-martial and have already served their sentences.
That is the Chief Justice when he was annulling the Supreme Court, the court-martial. So this did not go on well with the UPDF, because the UPDF was using the court-martial to settle scores. Various opposition leaders, they would go in their homes, plant just a red beret, and someone is taken on a court-martial, is remanded for years. Can you imagine? People like Macheta are still in the court-martial for 4 years. There have never been anything and has never been done to them. Okay, so the UPDF is in politics. It's the reason why even on political talk shows, officers come to debate with the opposition leaders. They put our mighty army, okay, in politics, which is not supposed to be the case. When the reading came out, the spokesperson Felix Kulaiji, one of the most incompetent officer, came out to say that they were being rolled in mud. In fact, he said these statements.
What happened in the Supreme Court? We were rolled in the mud.
But that's the role of the Supreme Court, to advise,
to roll us in the mud.
To advise and give you the legal knowledge of the decision and say, according to the knowledge we have as the supreme law of the land, we find this is not right. And because that's their job.
I wish that's the stating. You go pick some of the words they used. I told you that's rolling us in the mud.
Yeah, they said you're a disciplinary committee.
And if not, sure, that was an insult. We have a unit disciplinary committee that goes up to brigade. From a division, we have a court-martial.
That is Felix Kulaiji. So you clearly see that bring it back in our constitution, it is a law that has eyes. And it's very bad to form a law that has eyes. Because the reason as to why you must not make a law eyeing to catch someone is that power is not transient. Today you may be in power, tomorrow you may be in the opposition. Some of these people must learn to pass laws that they would want to be used on them when they're on the other side. And it's not happening. Okay? It's not happening. It's so unfortunate. In a letter which was sent to David Louis Rubongoya, inviting him to put his input, it reads as for reference: invitation for a meeting with the Committee on Defence and Internal Affairs to consider the Uganda People's Defence Force Amendment Bill 2025. On Tuesday, 13th May 2024, the Uganda People's Defence Force Amendment Bill 2025 was read for the first time and returned to Parliament Committees on Defence and Internal Affairs and Legal Parliamentary Affairs for scrutiny and report back. Accordingly, I have been directed by the committee leadership to write to you to a meeting on Wednesday, 14th May at 9 a.m. in Conference Hall B of the South Wing of the Parliamentary Building. During the meeting, you will be required to present your views on the bill and address any other matter that may arise. A copy of the bill attached for your information. Please come along with 20 copies of your presentation and send a soft copy to the undersigned at that email before the meeting date. For any further clarification, please contact the undersigned on mobile number blah 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 signed. That is a letter that was given to David Louis Rubongoya so that NUP can put an input. But in politics, nothing happens by mistake. This is a law that has eyes. It is a law that the Supreme Court came out to say that it's supposed to not try civilians. They are trying it to sneak it back so that, and since we are going in an election, it can be used against political opponents. It's so unfortunate. In fact, I keep on telling people that in other countries, court martials are not headed by military men, because the former setting, a court martial was not headed by a judge. Can you imagine being tried by people who know nothing about the law? In other countries, even court martials are not headed by soldiers, because there is no separation of power. A soldier only follows a command. Whatever his boss tells him to do to incarcerate you, he will do the same. In other countries, even if there is a case to be heard in the court martial, a judge, as Chief Justice, appoints a judge to hear that case, not a soldier. Okay? In fact, even these people, these MPs who are coming out to debate the court martial, they debate it only for civilians, but even soldiers don't get proper representation in this court martial. It is like a kangaroo court. A court martial must be headed by a judge who is appointed by the Chief Justice. And that judge must not be permanent. A judge is appointed according to what is the case available. That's how it's supposed to be. But passing this thing, it is going to be a monster. And we all know revolutionaries eat their own children. One of the very people who passed it will be the first people to suffer. I don't know how God does these things. The first casualty of the POMA Public Management Order Act was Amama Mbabazi, the proprietor. Grace Ibingira suffered the same detention without trial. The biggest casualty, I know, because history tells us, many of the times are the people who pass such laws. So for me, I think this law has eyes. It has eyes, and it cannot be taken for granted. This law must be struck down. But of course, since NRM has the majority, and these NRM members follow money like a fly follows a dirty thing, we all know that they were given 100 million shillings. That was a receipt to bring them back, because we all know at this time every member of parliament is in his constituency campaigning. They were given 100 million shillings. It is the reason as to why they are supposed to pass this bill. Okay? Many of them don't even know what's going in the country. I know they will come and vote. They will just sweep them up, come and vote yes. Since they have now numbers, it is more likely to pass. But it will be a dark day against our democracy. Trust me. Okay? It will be a dark day against our democracy. Of course, that's my opinion. Do make comments by commenting about this. Thank you very much for listening in. If this is your first time on the YouTube channel, employ to subscribe, like, and comment so that I can be motivated to do more of such videos. I'll see you on another one. Peace.
nange benjagala obulungi